Can you tell the difference between these two images? I hope you can. If you can, you're doing better than 7/9 of the Supreme Court. Yes, we're finally going to talk about Warhol. I really just need to do this. I covered it a little bit when it came out, but at the time people were telling me, nah, Shane, this is it. They're not going to use this. They're going to keep using Campbell. They're going to keep using Harper and Rowe. This is going to be minor. And what have we been seeing? Case after case after case after case after case. They keep relying on this horrible precedent where they completely messed up fair use. So we'll talk about what it is. But it starts with these two images. Now, the first is a photograph of Prince by Lynn Goldsmith. So she photographed Prince back when he was like this up-and-comer. And as you can see, she kind of captured his humanity, his humility, his vulnerability. Not his like superstar, like everyone else taking pictures of Prince, takes him dressed up in stylish clothes with a hat half over his eyes and everything. And this was very different. Well, Andy Warhol got a hold of it and then did what Andy Warhol does. As he had done with so many others, he took the image and transformed it into a completely different expression. Instead of showing a person of vulnerability with humanity, he used his method to show the dehumanizing effect of celebrity. How it's just all this artificial glitz and covering with barely anything of the real person left. And so this ended up getting used on the cover of Vanity Fair magazine, and then lawsuits ensued because Warhol was stealing Goldsmith's photo. What is it about a photo that you can copyright? What is it that makes it art? Because if this had been captured by a CCTV camera, no one would say it's art. But it wasn't. It was captured by a photographer. And when she took this picture, she made all sorts of choices about framing, composition, the shutter speed, the lighting, the focal length, depth of field, and even color grading. Yes, black and white is a deliberate choice here, along with how black are the blacks, how white are the whites, how much are the in-betweens. These are all aesthetic decisions that the photographer makes to interpret the image that the camera gives. Everything they do in the settings, everything about the way they frame it when they take the picture, everything they do in the dark room, or nowadays it's on computer software like Lightroom. All of those make up the expression. And copyright is only about expression, not a documentary fact, not an object. So yes, the Warhol silkscreen is absolutely based on Goldsmith's photo. But what expressive elements are left? Color? He redid the color. Shading? He took out all the shading. What about the depth of field, the focal length, everything? None of that made it over. Not even the composition. He reframed it. He cropped it. So he changed it so that there are absolutely none of the expressive elements left. And all of that is a new expression. So what are you left with? You're left with an image of Prince. Well, Goldsmith doesn't own Prince. I guess he posed a certain way. She doesn't own a pose. He can't own a pose. Well, because his hair is in that shape. You can't own a hairstyle. None of the expressive, copyrightable aspects of the image remain. And yet 7/9 of the Supreme Court looked at that and went, that's the same picture. So let's get into it. This is an 87-pager. We will not be going over all of it. Primarily, we'll be focusing on Kagan's Dissent, but still, this might end up being a bit long. God, Sotomayor wrote this. She is so dumb. I've got other videos about how dumb she is. Look at this here. This is on page 15 in the PDF file. And she's like, ooh, look, see, we've got this the same one. It's clear the same one. Yeah, we know that. We're not morons, unlike you. And the thing is, what they were deciding was just supposed to be about the first factor of fair use. Just to quickly go over it again, the first one is the purpose and character of the use. Second is the nature of the copyrighted work. Third is the amount and substantiality of the portion used. And fourth is the effect of the use on the market for the original work. It's just the first one that we're supposed to be looking at, which is how transformative is it? And this is pretty doggone transformative. So we'll see the extremes that she goes to, but she starts off summarizing what the district court said, which was actually pretty good. As to the first factor, the works were transformative because looking at them and the photographs side by side, they have a different character, give Goldsmith's photograph a new expression, and employ new aesthetics with creative and communicative results distinct from Goldsmith's. In particular, the works can reasonably be perceived to have transformed Prince from a vulnerable, uncomfortable person to an iconic, larger-than-life figure. The second factor was of limited importance because the Prince series works are transformative. For the third factor, Warhol removed nearly all of the photograph's protectable elements in creating the Prince series. And the fourth factor likewise favored the Andy Warhol Foundation because the Prince series works are not market substitutes that have harmed or have the potential to harm Goldsmith. Makes sense, right? They've got it. They've got the arguments right in front of them. Well, so did the Court of Appeals, but the Court of Appeals went the other way. The Court of Appeals rejected the notion that any secondary work that adds a new aesthetic or new expression to its source material is necessarily transformative. It's like, are you kidding? How much of our lives would be impossible if that were the case? So what does he have to do? It just says it has to be in service of a fundamentally different and new artistic purpose and character. Like what? Like not a picture of Prince anymore? Like not even recognizable as Prince? I guess so, because down at the bottom, they say the purpose is identical, not merely in the broad sense that they are created as works of visual art, but also in the narrow but essential sense that they are portraits of the same person. So as long as it still looks like Prince, it's not transformative. The only way, according to the Second Circuit, that this could be transformative is if it no longer resembled Prince at all. I sincerely hope I don't have to explain to you how ridiculous that is. All right, let's move over to page 18. So now we're getting into the Supreme Court's opinion. The only question before this court is whether the court below correctly held that the first factor, the purpose and character of the use, including whether such use is of a commercial nature or is for non-profit educational purposes. But the first fair use factor, listen to this, instead focuses on whether an allegedly infringing use has a further purpose or different character, which is a matter of degree. And the degree of difference must be weighed against other considerations like commercialism. Do you see what they're doing here? This is where they glom those first two factors together. You got to consider factor 2 when you're considering factor 1, even though you don't have to consider factor 1 when you're considering factor 2. That was the only way that they could find against fair use here. All right, let's skip ahead to page 34. Yes, it says 28. I'm using the page numbers of the PDF file as always, so you can follow along more easily. The Andy Warhol Foundation contends, however, that the purpose and character of its use of Goldsmith's photograph weighs in favor of fair use because Warhol's silkscreen image of the photograph, like the Campbell Soup Can series, has a new meaning or message. Warhol's Prince series conveys the dehumanizing nature of celebrity. But Campbell cannot be read to mean that Section 107.1 weighs in favor of any use that adds some new expression, meaning, or message. Otherwise, transformative use would swallow the copyright owner's exclusive right to prepare derivative works. Moron! Transformative and derivative are two different things. Derivative means you've just changed it a little, but you've still got the original expressive elements there. Transformative means that you've changed it so much that it's a new form of expression, which is exactly what Warhol did. So how would that swallow the copyright owner's right to prepare derivative works? It doesn't. It does the other way, because now the copyright owner's exclusive right to prepare derivative works swallows everyone else's right to create transformative works. All right, let's skip ahead to the last page of their opinion because it's so dumb I can't really deal with it. The use of a copyrighted work may nevertheless be fair, by the way, page 44 of the PDF, if, among other things, the use has a purpose and character that is sufficiently distinct from the original. In this case, however, Goldsmith's original photograph of Prince and AWF's copying use of that photograph in an image licensed to a special edition magazine devoted to prints, in other words, them using it on the cover of Vanity Fair, share substantially the same purpose and the use is of a commercial nature. The court has cautioned that the 4 statutory fair use factors may not be treated in isolation one from another. All are to be explored and the results weighed together in light of the purposes of copyright. But that doesn't mean you just ignore the first and most important factor. And what we're seeing, and we'll also see this in Gorsuch's concurrence, it's the idea that since they're both images of prints that can be used on magazine covers, they're the same. No, that's not good enough. Because if it doesn't compete with the original in any way other than any other completely unrelated picture of prints would, then it's transformative. But that's the big misreading of Warhol. That's a big one that they're using in these AI cases, and they're going to use it to destroy fair use, and next it'll be you and me every time we make a YouTube video. You think the DMCA is bad now? Just wait if these anti-AI cases go the wrong way. All right, in Gorsuch's concurrence over on page 49, check this out. Does Mr. Warhol's image seek to depict Prince as a larger-than-life icon, while Ms. Goldsmith's photograph attempts to cast him in a more vulnerable light? Or are the artistic purposes latent in the 2 images and their aesthetic character actually more similar than that? Happily, the law does not require judges to tangle with questions so far beyond our competence. Well, at least you recognize you're incompetent. But guess what? You don't need to. You have expert testimony. There were reams and reams and reams of testimony from independent experts explaining this to you. You're supposed to be looking at that. Instead, the first fair use factor requires courts to assess only whether the purpose and character of the challenged use is the same as the protected use. And here, the undisputed facts reveal that the foundation sought to use its image as a commercial substitute for Ms. Goldsmith's photograph. Oh, so now we're glomming in the 4th factor as well. Way to go, Gorsuch. Yeah, way to go. You managed somehow to be dumber than Sotomayor. And he says it again here on 51. If, for example, the foundation had sought to display Mr. Warhol's image of Prince in a non-profit museum or a for-profit book commenting on 20th century art, the purpose and character of that use might well point to fair use. But those cases are not this case. Before us, Ms. Goldsmith challenges only the foundation's effort to use its portrait as a commercial substitute for her own protected photograph in sales to magazines looking for images of Prince to accompany articles about the musician. That's not what commercial substitute means, you idiot! It's not just the same substitute that any other photo of Prince would have. And again, that's exactly what we're seeing in the AI cases. They're pulling that straight from Warhol, which, as we're about to see, doesn't come from anywhere else. And we'll see that here in the Dissent, written by Justice Kagan, joined by Chief Justice Roberts. What does it say when those two are the voice of reason? But man, I'll give it to Kagan. When she's on, she's on. All right, in the second page of her dissent here at the start of page 53, she starts giving us a crash course in art history. It may come as a surprise to see the majority describe the Prince silkscreen as a modest alteration of Lynn Goldsmith's photograph, the result of some cropping and flattening with the same essential nature. Or, more generally, to observe the majority's lack of appreciation for the way his works differ in both aesthetics and message from the original templates. What is worse, that refresher course would apparently be insufficient, for it is not just that the majority does not realize how much Warhol added, it is that the majority does not care. In adopting that posture of indifference, the majority does something novel, though in law, unlike in art, it is rarely a good thing to be transformative. Before today, we assessed the purpose and character of a copier's use by asking the following question. Does the work add something new with a further purpose or different character, altering the original with new expression, meaning, or message? When it did so to a significant degree, we called the work transformative and held that the fair use test's first factor favored the copier, though other factors could outweigh that one. But it's a continuum. Something could be a little transformative, in which case the other factors might make it not be fair use. Or it could be a lot transformative, and as I've pointed out repeatedly, if it's sufficiently transformative, that can absolutely outweigh all three of the other factors. It depends on how transformative it is, and it's hard to see how you can get more transformative than what Warhol did. Just as it's hard to see how you can get more transformative than AI training. This was always the threat of Warhol, and this was exactly what everyone was warning about. But today's decision, all the majority's protestations notwithstanding, leaves our first factor inquiry in shambles. It doesn't matter how different the Warhol is from the original photo, how much new expression, meaning, or message was added. It doesn't matter that the silkscreen and the photo do not have the same aesthetic characteristics and do not convey the same meaning. It does not matter that because of these dissimilarities, the magazine publisher did not view the one as a substitute for the other. All that matters is that Warhol and the publisher entered into a licensing transaction similar to one Goldsmith might have done. Because the artist had such a commercial purpose, all the creativity in the world could not save him. That doctrinal shift ill serves copyright's core purpose. The law does not grant artists and authors and composers and so on exclusive rights, that is, monopolies, for their own sake. It does so to foster creativity. How many times have I quoted this? To promote the progress of science and useful arts. And remember what the Constitution is doing there in Article 1, Section 8, is it's specifying the powers of government. So there are these boxes. Each clause is a different box. And as long as it's in this box, the government can do it, unless there's something in Section 9 or an amendment saying they can't. But if it's not in that box, it's not a power of government. So Clause 8 set up this box. And the box is the power they are granted. The power they are granted is not copyrights and patents. The power they are granted is to promote the progress of science and useful arts. The method by which they do that is copyrights and patents. So copyrights and patents are only constitutionally valid if they promote the progress of science and useful arts. If not, it's not a power of government. It's not in the box. So you can't do it. Let's be honest, Kagan says, artists don't create all on their own. They cannot do what they do without borrowing from or otherwise making use of the work of others. That is the way artistry of all kinds, visual, musical, literary, happens. The fair use test's first factor responds to that truth, as understood in our precedent, which the majority didn't really get, because they went completely against it. It provides breathing space for artists to use existing materials and fundamentally new works for the public's enjoyment and benefit. In now remaking that factor, and thus constricting fair use's boundaries, the majority hampers creative progress and undermines creative freedom. I respectfully dissent. And there's a footnote down here. I don't normally do those, but sometimes they're important. She says, one preliminary note before beginning in earnest. And oh my goodness, is she going to begin in earnest? As readers are by now aware, the majority opinion is trained on this dissent in a way majority opinions seldom are. Maybe that makes the majority opinion self-refuting? After all, a dissent with no theory and no reason, both of which are things they said about the dissent at length, is not one usually thought to merit pages of commentary and fistfuls of comeback footnotes. In any event, I'll not attempt to rebut point for point the majority's varied accusations. Instead, I'll mainly rest on my original submission. I'll just make two suggestions about reading what follows. First, when you see that my description of a precedent differs from the majority's, go take a look at the decision, which we've already done. We've looked at Campbell, we've looked at Oracle v. Google, we've looked at Harper and Row, we've looked at all those. Second, when you come across an argument that you recall the majority took issue with, go back to its response and ask yourself about the ratio of reasoning to ipse dixit. With those two recommendations, I'll take my chances on readers' good judgment. So she uses, as an example, Warhol's image of Marilyn Monroe, starting with a publicity photograph of the actress. He then went to work. He reframed the image, zooming in on Monroe's face to produce the disembodied effect of a cinematic close-up. At that point, he produced a high-contrast flattened image on a sheet of clear acetate. The same high-contrast image was then reproduced in negative on a silk screen designed to function as a selectively porous mesh. Man, silk screening is so fun. That's so fun. And so you see there how it ended up. And the meaning is different from any the photo had. But note what some experts say about the complex messages Warhol's Marilyns convey. On one level, those vivid, larger-than-life paintings are celebrity iconography, making a secular, profane subject transcendent and eternal. But they also function as a biting critique of the cult of celebrity and the role it plays in American life. With misaligned, day-glowed colors suggesting artificiality and industrial production, Warhol portrayed the actress as a consumer product, and in so doing, he exposed the deficiencies of a mass media culture in which such superficial icons loom so large. Out of a publicity photo came both memorable portraiture and pointed social commentary. And that got even bigger, and I want to show you this. It's really famous. It's called the Marilyns diptych. A diptych basically means there are like two parts of it, two panels. And I'll just read to you what the Columbia Journal of Law and the Arts had to say about it. Although some of Warhol's work was commissioned by individuals or companies, much of it was appropriated from other artists, photographers, and brands. Two of his most famous pieces, Marilyns diptych and the collection of Campbell's soup cans, are examples of his habit of appropriation. For the Marilyns series, Warhol took a promotional photograph of Marilyn Monroe and transferred it into silkscreen print using different colors. He did not own the promotional photograph that he used, and he did not have permission to use it. The resulting work was transformative enough that a strong fair use argument could be made today, but Warhol's appropriation is undeniable. This diptych was made just a few weeks after she died. And so that really gives you the clarity of what it's all about. The left side of the diptych is her in life, basically his original Marilyns series. And then after in death, it's black and white, it gets distorted, it's smudged, and slowly fades away. That's heavy, man. That's heavy. And he got all of that from a promotional still. Alright, so back to Kagan over on page 60. It does not take an art expert to see a transformation, but in any event, all those offering testimony in this case agreed there was one. The two works are materially distinct in their composition, presentation, color palette, and media, i.e., in pretty much all of their aesthetic traits. Certainly all the ones that you can copyright. If he transformed it so much that all of the copyrightable elements are removed, that's as transformative as you can get. Oh, but it's still an image of Prince. Well, she doesn't have a copyright on Prince. A thought experiment may pound the point home. Suppose you are the editor of Vanity Fair or Condé Nast publishing an article about Prince. You need, of course, some kind of picture. An employee comes to you with two options, the Goldsmith photo, the Warhol portrait. Would you say that you don't really care? That the employee is free to flip a coin? In the majority's view, you apparently would. Its opinion, as further discussed below, is built on the idea that both are just portraits of Prince that may equivalently be used to depict Prince in magazine stories about Prince. All I can say is that it's a good thing the majority isn't in the magazine business. Of course you would care. You would be drawn aesthetically to one or instead to the other. You would want to convey the message of one or instead of the other. The point here is not that one is better and the other worse. The point is that they are fundamentally different. You would see them not as substitutes, but as divergent ways to, in the majority's mantra, illustrate a magazine about Prince with a portrait of Prince. Or else you, like the majority, would not have much of a future in magazine publishing. In any event, the editors of Vanity Fair and Condé Nast understood the difference, the gulf in both aesthetics and meaning between the Goldsmith photo and the Warhol portrait. They knew about the photo, but they wanted the portrait. They saw that, as between the two works, Warhol had effected a transformation. Start by asking a broader question. Why do we have fair use anyway? The majority responds that while copyrights encourage the making of creative works, fair use promotes their public availability. But that description sells fair use far short. Beyond promoting availability, fair use itself advances creativity and artistic progress. That is because creative work does not happen in a vacuum. This court has long understood the point, has gotten how new art, new invention, and new knowledge arise from existing works. Our seminal opinion on fair use quoted the illustrious Justice Story. Yeah, you're going to go against Joseph Story. You're going to have a lot of precedent against you. In truth, in literature, in science and art, there are and can be few, if any, things which are strictly new and original throughout. Every book in literature, science, and art borrows and must necessarily borrow and use much which was well known and used before. And after quoting the precedents to pretty good effect, Stewart, Campbell, Harper, and Rowe, she says this case, of course, is about and only about the first factor, and that factor is distinctive. It is the only one that focuses on what the copier's use of the original work accomplishes. So page 65, in case you got lost, in Campbell, our primary case on the topic, we stated that the first factor's purpose and character test centrally concerns whether and to what extent the new work is transformative. That makes sense, we explained, because the goal of copyright, to promote science and the arts, is generally furthered by the creation of transformative works. Forgive me, but given the majority stance, that bears repeating. The critical factor 1 inquiry we held is whether a new work alters the first with new expression, meaning, or message. The more it does so, the more transformative the new work. And, here is the final takeaway, the more transformative the new work, the less will be the significance of other factors like commercialism that may weigh against the finding of fair use. Bottom of page 67. Now recall all the ways Warhol, in making a Prince portrait from the Goldsmith photo, added something new with a further purpose or different character, all the ways he altered the original work's expression, meaning, and message. The differences in form and appearance relating to composition, presentation, color palette, and media. The differences in meaning that arose from replacing a realistic and indeed humanistic depiction of the performer with an unnatural, disembodied, mask-like one. The conveyance of new messages about celebrity culture and its personal and societal impacts. The presence of, in a word, transformation. The kind of creative building that copyright exists to encourage. Warhol's use, to be sure, had a commercial aspect. Like most artists, Warhol did not want to hide his works in a garret. He wanted to sell them. But as Campbell and Google both demonstrate, and as further discussed below, that fact is nothing near the showstopper the majority claims. Remember, the more transformative the work, the less commercialism matters. The majority does not see it. And I mean that literally. There is precious little evidence in today's opinion that the majority has actually looked at these images, much less that it is engaged with expert views of their aesthetics and meaning. Warhol made only modest alterations. Anyone, the majority suggests, could have cropped, flattened, traced, and colored the photo as Warhol did. But the degree of difference is too small. It consists merely in applying Warhol's characteristic style, an aesthetic gloss, if you will, to bring out a particular meaning that was already available in Goldsmith's photograph. So too, Warhol's commentary on celebrity culture matters not at all. The majority is not even willing to concede that it even exists. The description is disheartening. It's as though Warhol is an Instagram filter, and a simple one at that, e.g. sepia tinting. What is all the fuss about, the majority wants to know. Ignoring reams of expert evidence, explaining, as every art historian could explain, exactly what the fuss is about, the majority plants itself firmly in the "I could paint that" school of art criticism. No wonder the majority sees the two images as essentially fungible products in the magazine market. Publish this one, publish that one, what does it matter? The problem is that it does matter, for all the reasons given in the record and discussed above. Warhol based his silkscreen on a photo, but fundamentally changed its character and meaning. In belittling those creative contributions, the majority guarantees that it will reach the wrong result. All of Warhol's artistry and social commentary is negated by one thing. Warhol licensed his portrait to a magazine, and Goldsmith sometimes licensed her photos to magazines too. That is the sum and substance of the majority opinion. Over and over, the majority incants that both works are portraits of prince used in magazines to illustrate stories about prince. They therefore both share substantially the same purpose, meaning a commercial one. Or said otherwise, because Warhol entered into a licensing transaction with Condé Nast, he could not get any help from Factor 1, regardless of how transformative his image was. From top to bottom, the analysis fails. It does not fit the copyright statute. It is not faithful to our precedent, and it does not serve the purpose both Congress and the court have understood to lie at the core of fair use, stimulating creativity by enabling artists and writers of every description to build on prior works. That is how art, literature, and music happen. It is also how all forms of knowledge advance. Even as the majority misconstrues the law, it misunderstands and threatens the creative process. It is the majority, not Campbell and Google, that misread Section 107.1. First, the key term character plays little role in the majority's analysis, and you can see why, given the counterintuitive meaning the majority every so often provides. When referring to the character of what Warhol did, the majority says merely that he licensed Orange Prince to Condé Nast for $10,000. But that reductionist view rids the term of most of its ordinary meaning. So the term character makes significant everything the record contains and everything everyone save the majority knows about the differences in expression and meaning between Goldsmith's photo and Warhol's silkscreen. It might be obvious to you that artists have artistic purposes, and surely it was obvious to the drafters of a law aiming to promote artistic and other kinds of creativity. But not to the majority, which again cares only about Warhol's decision to license his art. The majority spurns all that mattered to the artist, evident on the face of his work about expression, meaning, and message. That indifference to purposes beyond the commercial for what an artist most fundamentally wants to communicate finds no support in Section 107.1. Next, skip to the last factor. You might think that when Congress lists two different factors for consideration, it is because the two factors are, well, different. But the majority transplants Factor 4 into Factor 1. Recall that the majority conducts a kind of market analysis. One's a picture of print used on a magazine cover, the other is a picture of print used on a magazine cover. But it is the stuff of Factor 4, how Warhol's use affected the value of or market for Goldsmith's photo. Factor 1 focuses on the other side of the equation, the new expression, meaning, or message that may come from someone else using the original. Under the statute, courts are supposed to strike a balance between the two, and thus between rewarding original creators and enabling others to build on their works. That cannot happen when a court, a la the majority, double counts the first goal and ignores the second. Our precedent conflicts with nearly all the majority says. This court has decided two important cases about Factor 1. In each, the copier had built on the original to make a product for sale, so the use was patently commercial, and in each, that fact made no difference because the use was also transformative. If it's transformative enough, nothing else matters. That's what Campbell said, that's what Harper and Row said, that's what Oracle v. Google said. So the decision impedes non-copyright holders' artistic pursuits by preventing them from making even the most novel uses of existing materials. On either account, the public loses. The decision operates to constrain creative expression. The effect, moreover, will be dramatic. Return again to Justice Story. In literature, in science and art, there are and can be few, if any, things that are new and original throughout. Every work borrows and must necessarily do so. Creators themselves know that fact deep in their bones, and she gives about 1 million different examples. One of them being Shakespeare. I've used this. I've told this before. Shakespeare did not create Hamlet. Shakespeare did not create Romeo and Juliet. Those were existing stories. She uses Romeo and Juliet. Shakespeare's version copied most directly from Arthur Brooks' The Tragical History of Romeus and Juliet, written a few decades earlier, though of course Brooke copied from someone, and that person copied from someone, and that person going back at least to Ovid's story about Pyramus and Thisbe. And it was probably an old story back then, too. So if today's copyright law had existed back then, Shakespeare wouldn't have been able to do it, because it would have been less than 70 years after the death of the author. Shakespeare took plot, characters, themes, even passages. The friar's line to Romeo, "Art thou a man? Thy form cries out thou art," appeared in Brooke as, "Art thou a man? The shape saith so thou art." Shakespeare was, among other things, a good editor. Of course, Shakespeare also added loads of genius and so made the borrowed stories uniquely Shakespearean. But on the majority's analysis, the two works, Shakespeare's and Brooke's, are just two stories of star-crossed lovers written for commercial gain. Shakespeare would not qualify for fair use. He would not even come out ahead on factor 1. And she also says Lolita, though hard to read today, oh no, Lolita is good. It's a good novel. There aren't many Russian novels I like, but Lolita is one. It's usually thought one of the greatest novels of the 20th century, but the plot line, an adult man takes a room as a lodger, embarks on an obsessive sexual relationship with the preteen daughter of the house, and eventually survives her death, remaining marked forever, appears in a story by Heinz von Lichberg written a few decades earlier. Oh, and the girl is named Lolita in both versions. Nothing literary critics admire in the second Lolita is found in the first, but to the majority, just two stories of revoltingly lecherous men published for profit. And for the same purpose, they're put on a bookshelf next to each other. That's a market substitute. So even factor 1 of the fair use inquiry would not aid Nabokov. Alright, she gives a bunch more examples. I'm just going to skip to the end. Page 87 of 87. Still more troubling are the consequences of today's ruling for other artists. If Warhol does not get credit for transformative copying, who will? And when artists less famous than Warhol cannot benefit from fair use, it will matter even more. Goldsmith would probably have granted Warhol a license with few conditions and for a price well within his budget. But as our precedents show, licensors sometimes place stringent limits on follow-on uses, especially to prevent kinds of expression they disapprove, which are arguably the ones that need protecting the most. And licensors may charge fees that prevent many or most artists from gaining access to original works. Inhibiting subsequent writers and artists from improving upon prior works, as the majority does so today, will frustrate the very end sought to be attained by copyright law. It will stifle creativity of every sort. It will impede new art and music and literature. It will thwart the expression of new ideas and the attainment of new knowledge. It will make our world poorer. And it is doing so. This keeps showing up over and over and over again, and we've seen it, and hopefully you now know how ridiculous it is, just as most of the rest of us have always have. Thank you so very much for watching. Comments for the Comic God, shares for the Terror Throne. Please hit like, subscribe, and the bell. And of course, if you want to keep me doing what I do, donate.bogosity.tv. One-time donations or regular support. Thank you so very much for watching, and until next time, stay strong and be free.